Testing appellant mic. All right. That's a little loud. Testing appellee mic. Appellee mic 1.
Well, I'm with you because I think my case falls into that because they actually did it this last round, found this one. And my
Judge microphone 1. Test. Testing judge microphone 2. Testing justice mic 3. Testing justice mic 4. Testing justice mic 5. Testing judge microphone 6. Testing judge microphone 7.
law court at Portland within and in the state of Maine, they come forth to declare, and they shall be heard.
Good morning, you can be seated. The matter before the court is Knox 2510, Pat Doe versus Jeffrey Weymouth. Counsel, I see, are present. We are being streamed on the web, both by audio and by video. And if counsel would introduce yourselves by saying your names for the record together with the party you represent, starting with the appellant.
Attorney Jeffrey Sherman, here for the appellant, Mr. Jeffrey James Weymouth.
And Eric Morse, Your Honor, for the appellee, Pat Doe.
Thank you, counsel. And Attorney Sherman, if you're ready to proceed, we'd be happy to hear your argument this morning.
Thank you, Chief Justice Stanfill. May it please the court. This case is about the breathing room the First Amendment gives all of us to speech, to joke, to vent, even to be immature, without suffering the consequences of a court order, losing custody of your child, and losing your right to possess a firearm. The freedom of speech protects that breathing room because speech is often messy and imperfect. And speech is often messy and imperfect because life is often messy and imperfect. The First Amendment ensures that as long as a person does not cross the line into true threats, they have the space to speak how they feel. True threats are serious expressions conveying that a speaker means to commit an act of unlawful violence. Objectively, a reasonable person must interpret the statement as a true threat. Subjectively, the speaker must act at least recklessly. This case is based on 3 instances: a Facebook post that was a joke to Mr. Weymouth's friends after a divorce, a mailbox incident where he loudly closed a copper mailbox and sent a rude text message, and a poster that was an unflattering commentary on appellee's romantic history. Because of these 3 incidences, the court found a course of conduct, made a finding of abuse, issued a 2-year order, and took away Mr. Weymouth's custody of his 9-year-old daughter. I'll focus on 2 arguments this morning. The first is that the Facebook post and the poster are not true threats. A reasonable person would not interpret them as a true threat because there's no explicit references to violence in either, or there's no context between the parties that would transform these into true threats. And also, Mr. Weymouth did not act recklessly. And second, setting the First Amendment aside, the conduct here does not meet the statutory definition of abuse. So starting with the Facebook post, which we've brought a demonstration in for the court, and you can find it on page 7 of our brief. This was posted 3 days after the party's divorce. Appellee could not see the post because Mr. Weymouth had defriended her, and she only saw it because a friend had sent it to her. The post does not mention her by name. There's no caption or text on it of any kind. And the photo was staged in several ways. There's a hat that he's wearing that says, "This actually was my first rodeo and last." There's a book on the shelf behind him about life transitions. It's called The First Pancake, a Recipe for Delectable Life Transitions. He's smiling.
Counsel, I see that the green light is on. First, I want to make sure I hone in a little bit on the argument. You're not arguing, as I understand it, that there's anything wrong with the statute itself, the standard that the statute poses.
The PFA statute?
Correct.
No, it's the application here.
Okay. And so do you agree that the judge made findings that meet the statutory standard? What he said meets the standard?
If the court accepts those findings, then
Okay.
I guess it could be.
So really, this is nothing more than a sufficiency of the evidence argument?
This is a de novo review of the First Amendment claims as it
Well,
relates to the
but
Facebook post.
But I think you've just conceded that the statute, the standards in the statute comply with what's required under the First Amendment. The judge made findings that comply with the statute. So really what you're saying is, however, those findings are not supported by the evidence.
Yes. To the extent that this court will look for the first time or de novo review on
Well, we don't review findings by de novo, do we?
the first,
Factual findings, sufficiency of the evidence.
That's clear error, correct?
the First Amendment question based on those findings would be de novo review. But I suppose the factual findings themselves are maybe clear error. The issue here is that to the extent the court found that there were explicit references to violence in the Facebook post, the district court got that wrong.
You opened your comments here by saying that statements can be made in a joking kind of way. May sound like a threat, but everybody knows it isn't a threat. If you do that again, I'm going to kill you. I'm not really going to kill him. It's just something to sort of jokingly express my dissatisfaction with what he's doing. So in my mind, it seems unlikely he would take it that way. But we're not. If the speaker, if the poster intends it as a joke, but disregards the fact that the person who perceives it may not perceive it as a joke. They're kind of disregarding that. And getting back to the Chief's point here, what the judge basically did by making the findings is saying, no, this may have been intended as a joke, but you disregarded the fact that on the receiving end, which is what matters, it wasn't taken as such. Aren't we bound by that finding? Basically, the judge is saying the recipient didn't think this was a joke, and looking at it, that was a reasonable conclusion. Doesn't the analysis stop there?
I don't believe so. The district court, let me rewind. During closing arguments, trial counsel raised a First Amendment issue. The court ignored that argument and found that there was abuse and made factual findings about that.
But the court made factual findings that complied with, if supported by the evidence, and I understand you're suggesting that they're not, findings that complied with the First Amendment argument.
And this court would also now look to see whether those findings, whether this speech is a true threat or not.
Well, let me ask you about that. You're not suggesting that all speech must be a true threat in order to be considered as part of a course of conduct.
When it relates to speech, there's protected speech and there's unprotected speech. Here, the category of unprotected speech.
Well, and that works when you take one statement or what is alleged to be a threat in isolation, and if this were under 4102(1)(e), i.e. threat, that it was based solely on a threat. But that's not what the judge based this on. He based it on a course of conduct and don't we then have to analyze all of it as a whole? Does each statement have to stand alone as a true threat if what we're basing it on is a course of conduct?
I think that the speech that's contained within the course of conduct, to the extent that this is based on the Facebook post is speech and the poster is speech. So the extent that the course of conduct is based on speech, then those must be unprotected.
But there was another element here. There was another action which was not speech. You concede that, the slamming of the mailbox.
The mailbox incident, there is no speech.
Let me come at it from a different angle, if I could. Are you saying that a joke or a person venting or a person acting immaturely can never constitute a true threat?
No.
So it comes down to the particular facts in a case. Right?
Absolutely.
So even though a person may intend it as a joke, oh, I was just joking, that could easily mask a malicious intent or a reckless expression, couldn't it?
Absolutely. And I think that's what's important about the test that the Supreme Court laid out in Counterman, is to say we're looking at first the objective. Would a reasonable person interpret this as a serious expression that
A reasonable person in the shoes of the plaintiff?
Yes.
Okay. A reasonable person who just went through a divorce and a contentious situation, and there's some animosity. That's the perspective that we look at for purposes of taking a reasonable view, right?
Would a reasonable person in her shoes
Correct.
find that this is a threat of physical violence?
So we look at the circumstances that relate to the specific events that are purported to be the threatening acts, correct?
Absolutely. And the
And so in this context, there are more things going on, as Justice Douglas was alluding to, but also specifically there was testimony, at least from the plaintiff, about issues that were endemic to the marriage, problems with drinking, also anger issues. We would look at those factors as well, would we not?
absolutely. So
And
they
so
were-
from her perspective, this could be viewed as a scary escalation post-divorce, that the, anger has not dissipated, but is rather seems to be increasing. Isn't that, isn't vindictive or tormenting behavior sufficient if indeed it places the person in fear?
not if it's not if it doesn't reach the level of true threat, then the speech would not be. And the context here, I think, is really important. There was no history of violence of any kind between the parties. To be clear, there's no evidence that was presented that Mr. Weymouth was ever violent towards Apelli or any other person. None of that came in or was presented because it never happened.
But there was finding from the trial court that he told his ex-wife that he would use a gun to kill himself, and that he had problem with anger. Isn't that part of the context we can consider in determining whether, a reasonable person in her shoes might perceive these as threats to violence?
I definitely think those are both relevant factors. I'll address the anger issue first. She testified that he had anger issues. She didn't testify how it ever affected her. She didn't testify as to any specific instances of anger impacting.
But was that point ever refuted by the defendant in his testimony? I don't recall that.
It was not. But there was no specific how this impacted the Facebook post or how it impacted the poster. As it
Well, she
relates,
talked about how those particular items impacted her, given the context, did she not, in her testimony?
those were brought in to support her reasonable fear. As it relates to the suicidal ideation, I do not believe that those transform the poster or the Facebook post into true threats. So he said, Apelli testified that Mr. Weymouth expressed suicidal ideation to her, and that if he did kill himself, if he died by suicide, he would use a gun. But there was no testimony about when these comments were made, how serious they were, or how they had any relationship to the Facebook posts or the images in the poster. And I don't think it's clear that threats of suicide correlate explicitly with threats to harm anyone else. And the best example of this is that the O'Dara score that Maine courts use specifically says that.
I note that the red light is on. I'll also indicate that a DARA score is a score that doesn't apply because it has to do with recidivism. But I note that the red light is on.
Sure.
Good morning. May it please the court, Chief Justice Stanfill and members of the court. What's important here is that speech was a part of a course of conduct that was directed at the appellee.
Well, but do we have to analyze each element? In other words, even if it is a course of conduct, when a course of conduct involves speech, do we have to look at each instance to ensure that we are not having a chilling effect on what is otherwise protected speech?
I don't believe so. I mean, I believe it's the totality of what was intended here, that this was received as an escalating course of conduct to intimidate, threaten, and place someone in fear, and it was successful. And what's significant, and I think there was some questioning about this, there was threats of suicide with a gun that the district court judge relied on as part of his finding, as part of the finding that the abuse occurred, that was never refuted. That was not denied. So the evidence that there was a history of anger problems, history of suicidal ideation, access to guns, a threat to commit suicide with a gun, that was never denied by Mr. Weymouth.
Let's talk about the evidence. I mean, the evidence showed that the Facebook post that he made, that she was blocked from his Facebook page. Is it sustainable then to say that it was really directed at her if she is not even able to access it and he knows that?
Absolutely, Your Honor. Everyone knows, and there's actually case law court case law that says Facebook posts such as that, the person that's posting those social media posts knows that they're likely to be seen. And that's in fact what happened here. And there was evidence that multiple people reached out concerned about her well-being and concerned that these were threatening statements. So,
what about the poster? I mean, what is the evidence that ties it to him?
Yeah, the poster is a huge point, right? Because the poster at trial in the district court, there was an elaborate effort to distance Mr. Weymouth from the poster. And this was a big cat and mouse game where his mother actually came in and committed perjury.
Well, I understand that but that still leaves you with what is it that connects it that he's the one who's responsible?
Because he's definitely responsible, and that's what the trial court found, because the pattern...
I know that's what the trial court found.
Right.
I want to know
The symbolism that was in the poster is exactly textbook Mr. Weymouth. So this is what had been seen over and over again, and he was asked about it, and even he on cross-examination said, yes, it is very similar, I agree. And remember, what's so concerning about that is that the appellee lives on a quiet residential street, right? Not a busy pass-through street. And that he actually went with a laminated poster and put this on her street so she would find it. And it's labeled warning, right? He's saying warning. This is part of this escalating pattern. And this is getting harsher and harsher. And there's the gold digger reference and the Black Widow reference because money was a big issue. Slams the mailbox. You got your subsidy check. That was what he texted her, right?
But can't the context of the warning be, he claims that he's warning other men that she's a black widow, she will eat her mate. Right. Look what's happened to these three guys here. I mean, that's how he interprets it.
Right. That's a great question, Your Honor. If that was, remember where it was put. This was a laminated poster, not a Facebook post, just so we're all clear about that he had to sneak onto the street and hang it for her to find. And in fact, he went to great lengths at hearing to say, I didn't do that, I'm not responsible, you can't hold me accountable, and that was not believable, right?
But even if she was intended to see it, if you accept his interpretation of what it conveys, which is basically a criticism, it's an act of disrespect to his former wife and saying basically she's a black widow, which eats, the female eats the male mate. But the court here seems to suggest that the placement of the Black Widow spider on there meant that he intended harm to her, which is sort of standing on its head. Do we make anything of that, or is the court's finding sufficient on itself that we don't look behind it?
Well, I think the court's finding is sufficient, but I think it's also important that that poster was intended for an audience of one. That poster was placed on her street, intended laminated so it wouldn't be damaged by weather, right? He wanted to make sure that that survived if it rained or something happened, and it was given to her and she was terrified when she received it. And remember, it depicted her minor children from prior marriages, Your Honor. And one of the photos, she testified clearly, was taken from her garage. It was not anywhere else available.
I mean, is that really the crux of not so much that each individual, that post or that the poster itself were threats in and of themselves, but rather that it was, an escalation of behavior that, from her perspective, he must have come into the garage to get a photo, came to the house to deliver a check when it was supposed to be by direct deposit.
Right.
Left a poster near her house, and so those actions, in combined with the nasty, at a minimum, nature of the
Right.
communications.
Yes, and putting the children, too, was the thing that really crossed, and that's what she testified to. All of a sudden, it's a warning, and here are your children, and here's a photo that could only be obtained from your private garage that's included.
Wasn't that disputed quite vociferously at trial, that there were cameras around the
Yes.
property, and how could he have possibly gotten into the garage to go through the
Right.
bins to get one picture out to put in the poster board?
No, it's a great question, and I think what we have here is there was no motion for further findings of fact, so we don't know for certain whether the district court judge considered that as part of the overall panoply of what this behavior was.
He didn't make a finding as to whether the photo was taken from
He
the garage.
didn't make a finding, but there was no, but in the record, Your Honor, I would submit, is clear that there was evidence about that. It was challenged, but much like everything else that Mr. Weymouth testified to at that hearing, it was rejected. He was not credible. And again, the clear error standard is a deferential standard because the district court judge is in the best position to
Well,
evaluate
they're
credibility.
arguing that this is entitled to a de novo because of its implications for the First Amendment. What say you to that?
Well, I think, again, when they just got up to argue it, they conceded that he complied with the statute. I mean, the judge made a very, again, this was unusual to me in the sense that Judge Mattson was so unbelievably thorough. I couldn't get over it when he came back in. He took a recess, he took about 15 minutes, and then he came back in and he gave detailed findings on the record, which I don't see that. I do this work day in and day out, and I don't see that very frequently. And
Counsel, was the poster speech or conduct?
I think it was a combination of the two. You can't, right? You can't separate the two because
But the essence of it, its significance, it's speech, isn't it?
it's both. It represents more than just speech. It is speech, but it's also being placed on a quiet back street, right, where she's going to find it for an audience
Well,
of
how's
one.
that different than putting something on Facebook? I mean, it's speech, isn't it?
It is speech, but it is different than Facebook, though, because it's directed at one person.
Okay.
If
But
I
it's
make
still, in one case it's broadcast, in the other case it's directed, but it's still essentially speech, isn't it?
it is, but
So isn't this, do you agree that this is a true threats case?
again, based on I think the statutory requirement's been met. It's a course of conduct that involves speech and conduct.
Well,
and
suppose you have a situation, and maybe this is one, where the course of conduct is predominantly speech. As I don't know if you would concede that here, but it would appear to me that the course of conduct here is predominantly speech. There's other components, and the court can take a look at those as well and call it a course of conduct, but there are significant elements here that are speech, aren't there?
that's true, and I think.
So doesn't the counterman framework apply?
Well, even if the court takes that position, then take a look at just the threat to commit suicide with a gun, right? That's a separate, that alone, under the Protection from Abuse statute, is enough to support a finding of abuse under the statute, right? The legislature said it's a course of conduct or specific acts, including terrorizing, which is what he did, and that wasn't even refuted. That was never challenged, and the court made a specific finding that he considered that was an important factor.
You're suggesting that the threat to commit suicide meets the standard under subsection E, communicating to a person a threat to commit or cause to be committed a crime of violence?
Yes, and under Allen versus Ray, which is the court's 2019 case at 299 Maine 53, the court, that was a protection from harassment analysis where the court said the course of conduct wasn't good enough, it wasn't sufficient, but there was one criminal act and that qualified, so they affirmed the district court's decision to grant a harassment order. Same analysis here. I mean, you can look at, you've got a broad swath of conduct and statements, including, most importantly, the threat to commit suicide, which was never challenged. It was never challenged.
What
And
if
so
we find this wasn't a true threat?
I'm sorry.
What if we find that this was not a true threat, the communications that took place here?
Well, then I think that could change it, but I can't see how.
Well, would time, place, and manner restrictions be applicable in this circumstance?
You know, I'm not so sure. I'm not so sure. I think you need to look at all of the aspects of this, including the suicidal threat, including the conduct of placing it on the street. All of it is relevant as far as I'm concerned.
Counsel, it seems to me in determining whether these are true threats, the district court, and now you are saying there are a lot of inferences that had to be drawn, and that it's really close. You know, you could draw the inference the other way, and it would be favorable to Mr. Weymouth. You could draw it this way, it would be favorable to your client. Would your position be in that circumstance that you win because of the clear error standard of review?
Yes. Yes. I think the deferential standard that needs to be applied, that basically it's critical to be in a position to assess the credibility of the witnesses, how they act, how they testify. Again, there was a lot of drama in this case. It was not straightforward. It's not like Mr. Weymouth came in and said, yes, I made that poster and I placed it on our street and I was just expressing my First Amendment rights. He adamantly denied that he did it, and it was not believable. And he went to those great lengths because he knew that this was going to be received by the appellee, which in fact it was.
Well, if the First Amendment is implicated, should we give this stricter scrutiny beyond clear error because of the chilling impact that on the First Amendment if we don't have a more rigorous review?
Well, I don't believe so. I mean, it was conceded that the district court judge applied the statute and did everything appropriately, and there was no suggestion that the statute is unconstitutional.
I'm not saying the statute's unconstitutional. I'm saying, should our standard of review be more rigorous?
I don't believe so. I believe it's, you know, that prong is the clear error standard. So, and I think for good reason, again, because who's in the best position to make those determinations and to evaluate witnesses?
Well, doesn't it depend on whether it's a true threat or not? If it's a true threat, it's not entitled to First Amendment protection.
Well, that's correct. And I think, and the district court judge made those findings, that he found it was in fact a true threat, that it was violent, it was received that way, and it was intended to create a reaction from the recipient, and in fact, it was successful. Sadly enough, it was. And this person was placed in extreme fear. And it's really the whole pattern. And I think some of the court's questions at the beginning are really important, that it's this escalating pattern that following the divorce, remember, the appellee was responsible for monitoring SoberLink, which was being violated repeatedly. So contact pursuant to the divorce judgment was being suspended. And at the same time, there were these financial obligations that the appellant had, and he was ripped. He was so angry that he had to do this and that there was this control over him. And you could see the pattern as it developed. The mail, you know, the Facebook post, the mailbox, you know, the poster that was created and placed on her street, you know, the threats of suicide that had preceded that. So it was this whole pattern that I think is really important to look at that context.
Can I get you to clarify one point in the record, which may be a minor point, but opposing counsel in this presentation was, I think, suggesting the court went overboard with respect to its interpretation of the facts and implementation of a 2-year protection order. I thought that the protection order was only put into effect for a 1-year period. Am I mistaken?
No, it was a 2-year period. My understanding is one.
I think it,
Oh, it is? Okay, maybe it is 1 year.
I think
All
it's
right,
a
I'm
1
sorry.
year.
All right, I stand corrected. All right. Yes, so, and that's what it is. And as far as the argument that it affected custody and other things, again, there's a family matter and there's other avenues to, you know, affect change in the protection order. It's not meant, it's intended, obviously, to keep the plaintiff safe, and I think it achieved its goal, and I think there was absolutely sufficient evidence to support the finding that the district court made. So if there are no other questions?
there don't appear to be, thank you.
Okay, all right, thank you very much.
Attorney Sherman, you reserve 2 minutes for rebuttal.
So regarding the chakra gesture that we haven't really discussed, there is no evidence that that gesture is aggressive or violent. Appellee never testified that the shocker was aggressive or
Well,
violent.
it's a little unclear whether she did or didn't, I'm going to suggest. The question, I think at page 26, was something about a lewd and violent sexual act. Although there was, at one point, an objection, it did seem to come in. So I'm not sure it's true. She said it was disgusting, vile, and gross, took it as a veiled threat. So I think there is some evidence.
She referred to it as crude and rude and lewd and a construction of meanness.
And disgusting, vile, gross, and agreed that it was a lewd, violent sexual act. It's in the transcript.
The evidence of it being, well, moving on. This case matters more than the two parties before this court. The district court's decision and the standard appellee asks will fundamentally change what a protection from abuse order is. If this judgment stands, the district courts will become flooded with Facebook posts, Instagram photos, and TikToks.
They already are, I promise you.
The courts will be asked to squint hard enough to see speech in its worst possible context. The answer here and the safeguard that prevents this slippery slope is the true threat standard.
Is any of your part of your argument changed by virtue of the fact that she requested a 2-year order and was only granted a 1-year order after the court considered all of the evidence before?
It would not change the issue that this is a true threat. The First Amendment analysis would be unchanged.
Thank you. As is our usual practice, thank you, counsel. We'll take this matter under advisement, issuing a written decision in due course. Attorney Sherman, I understand this is your first appearance in front of this court. It is our tradition to invite counsel back to take the greetings of the court, and so we look forward to meeting you.
All rise.
morning. You can be seated. The matter now before the court is BCD 2563. It's Waldo Community Action Partners versus the Department of Administrative and Financial Services, DHHS, et cetera. And I see counsel are present and apparently raring to go. And we are being streamed on the web, both with video and with audio. If counsel would introduce yourselves by saying your names for the record together with the party you represent.
My name is Brent Singer. I represent Waldo Community Action Partners.
My name is Halliday Moncure. I represent the Department of Administrative and Financial Services.
My name is Margaret Hayek. I'm an Assistant Attorney General and I represent DHHS.
Okay.
Sarah Rechnickel for Medicare Solutions LLC.
Bob Ridge, I also represent Medicare Solutions.
Thank you. Attorney Singer, if you are ready to proceed, we'd be happy to hear your argument this morning.
Thank you and good morning. Cost was not a factor in this bid because each bidder agreed to accept the rates set by the state. Section 1825-B7, cited repeatedly in our brief, requires that the contract be awarded based on the quality of the services to be supplied. Waldo Cap lost its bid to continue supplying the Region 5 services because it identified its work as Maine DOT's designated federal transit authority and its work for other state agencies at the start of Appendix D, not in two boxes at the end. The reviewing panel's individual evaluation notes and the team notes explicitly comment that Waldo Cap is Maine DOT's Region 5 Federal Transit Authority, and Waldo Cap works for the Office of Child and Family Services and other state agencies. Although the panel acknowledged these examples appearing in Appendix D, it deemed Waldo Cap to have omitted them entirely because they were not in two boxes at the end of Appendix D. There's no dispute that Waldo Cap lost its bid because it was deemed to have omitted these examples entirely, for which it was penalized 7 points in the category of organization qualification / experience. Those points cost Waldo Cap the bid. And where Waldo Cap put its examples of other work for the state in Appendix D, in its Appendix D, has absolutely nothing to do with the quality of the services it would supply, it has supplied, or its qualification / experience to supply them. It's undisputed, which of course is more than clear and convincing, that the only reason Waldo Cap lost, therefore, has nothing to do with the quality of services it would supply. That violates the plain language, the intent, and the spirit of the statute. Even more astonishing is this. Waldo Cap scored much lower than Motive Care in organization qualification / experience for Region 5, even though Waldo Cap has been supplying these very same services in Region 5 to the complete satisfaction of the state for the past 12 years. Waldo Cap also scored higher than Motive Care in the category of proposed services to be supplied, the most important category in the RFP. The record is thus clear and convincing, we believe, that the award to Motive Care was not just senseless, but contrary to the plain intent and spirit of the statute in a circumstance like this.
Well, let's go to the statute. It says that except as otherwise provided by law, the competitively awarded orders or contracts must be awarded to the best value bidder, taking into consideration various factors, including, quote, their conformity with these specifications. You concede that you didn't follow the specification, correct? You didn't put projects in those boxes.
The reference to specifications in the statute plainly refers to the specifications in the RFP for the goods or services to be supplied, in this case, the services to be supplied, not the specifications as to where to put things in what box or that sort of thing.
And the RFP says that the proposal must follow the outline used below, including the numbering, section and subsection headings. Failure to do so or to respond to all may result in it being disqualified as non-responsive or receiving a reduced score. I mean, that's right in there.
The RFP also nowhere says where the examples have to go in Appendix D.
Well, it says, also, I'm looking at Appendix 95, that they must complete Appendix D qualifications and experience form describing their qualifications and skills. Bidders must include 3 examples of projects which demonstrate their experience and expertise. And then when you look at the form for Appendix D, it has boxes: Project 1, Project 2, Project 3. And only Project 1 was completed.
That's because we had already, the Waldo Cap had already given other examples of its.
But they're not asking for examples, they're asking for specific projects. And under Project 1, it says Office of Maine Care Services.
Well, working as the designated federal transit authority for Region 5 is a project. By the way,
but they're looking for.
It's not defined in the RFP, which has a zillion definitions at the start.
But they're looking for detailed information. What are we to make of the appeal committee's finding that Waldo Cap's failure to supply information as directed by the RFP inherently affected the review team's substantive evaluation of the proposal because the team lacked the kind of detailed information about previous projects that other proposals included? So they're looking for additional detail.
I don't think the record supports that conclusion. I think most important, for example, is if you look at appendix page 130 cited, which is the team consensus evaluation notes, showing that they took 7 points away from Waldo Cap in organization qualification / experience. It says bullet 1 only provided a description of one project example. But that's just false. Their same notes then say provides transportation for DHHS Office of Child and Family Services. Waldo Cap provided some performance measures for that in Appendix D,
Well, it
albeit not in the box at the end.
It referenced the project, but it didn't really provide a description, did it? I mean, let me ask another question.
Sure.
Those 2 boxes weren't just left blank.
It said NA.
It said NA.
Right.
Not applicable.
Right.
How are the evaluators supposed to interpret that?
Well, I don't think they were called, first of all, interpreting that calls for no agency expertise. But secondly,
what do they think
don't
it
have to
means?
interpret that. They just have to look in Appendix D to see if there's other qualifying examples. And Mr. Bondison, who was the subject matter expert, I don't make that up, that's what he said he was, other people agreed on the panel. He said, yeah, these other things, Federal Transit Authority and work for the Office of Child and Family Services, they qualified, but they weren't where we thought they'd be.
Well, they also didn't provide all the information that was specified in the boxes.
Well, nobody is, if you look at the team consensus notes, again, App 130, nobody says, oh, they didn't give a phone number for Maine DOT, or they didn't
No, they
give
said they didn't complete it.
The legislature intended, especially when cost is not a factor, that what is paramount in the award of the bid is the quality of the services to be supplied and the ability to supply those services.
And
Not whether or not you put it in the box.
And the best interest of the state is also mentioned. How should we interpret that phrase?
As the legislature would have intended it in a situation like this, and where Waldo Cap has been continually supplying the same services for 12 years to the satisfaction of the state. It just makes no sense to say that it lost the bid because it has inferior organization qualities and experience. There are meaningful indicia of that the RFP asks for. It asks for financial statements, it asks for payment and performance bond, it asks for insurance, it asks for something to show you have adequate staffing. Waldo Cap passed with flying colors. Or the litigation, is there problematic litigation? All those things actually go to whether or not the bidder can supply the services in question.
Would it be improper for the department to, in looking at whether or not CAP was the best value bidder, that the best value bidder would have complied with the government's request to fill out the form with the details and requested there? So they may be terrific on the ground with patients, other people they're dealing with, but they didn't file the proper information coming back. Why shouldn't that be it?
The RFP, all of which is in the appendix, is internally inconsistent. It also says we can take into account your contract history with the state, even if you don't say anything about it. Now, I'm not saying that obligates them to do it, but I am saying that they really didn't need to say anything more about what they... DHHS knows what Waldo Cap does for the Office of Child and Services and what it does for the Office of Disability
For the purposes of an
Services.
RFP, they can't assume that. It's an application process. It's a competitive process.
Right.
To simply say that they can intuit or they can remember or infer seems to go past the RFP process.
It's a competitive process to determine who can supply the best services to the state, basically. I mean, that's it. I mean, this is not there's not some meta thing there. The legislature didn't say, well, what we mean by best interests of the state isn't really who gives us the best service for the best bang for the buck or whatever.
Well, they're also allowed to promulgate regulations. There's a statute, and then the regulation says award must be made to the highest rated proposal which conforms to the requirements of the state as contained in the RFP.
And that's where Appendix F comes in. That's the core. Appendix F, it's the category of proposed services in this RFP, is where there's like...
You're saying you conform to the requirements
those are the
of the RFP.
Right. Those
When
are
the RFP
requirements,
said, please fill in these boxes, and you
which
said
have
NA.
nothing to do with the quality of
Yeah, but it's not
services.
just-
The specifications for Appendix F are technical, they're lengthy. Waldo Cap's Appendix F was
Counsel, can I say,
207
you keep denigrating it as it's a matter of filling in boxes, but what it asked for was you to describe in full 3 separate projects as a way of understanding the experience and expertise that you are presenting. Under Project 1, it's one project that's described in detail, and that is the service that's already being provided, that is the subject of the RFP. But 2 other projects were not. How is that complying?
I believe that understates how much information was contained in Appendix D about its work as the designated federal transit authority. I don't recall anywhere in the RFP where it says a full description.
Can I ask you just a hypothetical question? If you're interviewing lawyers for a position with your firm, and one of the application form says, describe 3 cases that you've had with the details and all the particulars on it, and all of the applicants except one give you 3, but one of the applicants, well, I did Jones versus Smith. The other 2 boxes I'm not going to fill in. Would you not consider that as one of the big picture things you would look at in interviewing a prospective person to be joining?
You may answer.
If the applicant had been doing an excellent job as a lawyer in the field of law that we want to hire for, then if they were a little skimpy in those descriptions, we'd still hire the excellent lawyer, because that's what a good decision is.
Thank you, counsel. Attorney Moncure.
May it please the court, my name is Halliday Moncure. I represent the Department of Administrative and Financial Services. We ask the court to uphold the DAF's decision, which is supported by substantial evidence in the record, as set forth in our brief. The decision complies with applicable law, and it is a proper exercise of the agency's discretion. Contrary to Waldo's arguments, this is not just a matter of form over substance. Indeed, the substance itself was lacking. Waldo's bid failed to comply with the RFP because it did not include the 3 project examples at the end of Appendix D. We disagree with the characterization of Mr. Bondison's testimony. He did not agree with counsel on this point. Additionally, although Waldo waived this argument because it was not made before the administrative level, its interpretation of what best value means under Title V, Section 1825B7 is too narrow. There are several factors for an agency to consider in addition to quality, one of which is conformity with the RFP's specifications and the best interests of the state. Agencies have broad discretion to determine with whom they wish to contract, as long as they comply with the state's procurement requirements. The record reflects that DAF's fully complied with the law here, and its decision should be upheld. I welcome the court's questions.
So what this kind of boils down to in one argument is they screwed up. They did not put the right information in the right place. And in those 2 boxes, they didn't put exactly the right, like the contact phone number. One of their arguments is that seems like it's a big deduction for a small hyper-technical requirement. Why specifically was the bid number reduced to so much for that mistake?
Your Honor, the consensus scoring process is focused on reaching a consensus among the evaluators for bids in competitive procurement. And the record reflects that the evaluators considered carefully all of the proposals here. There were over 20,000 pages worth of documents.
Isn't the problem, though, with consensus scoring is that we don't know what criteria in the end are actually used? Why a 7-point deduction? Why a 12-point deduction? Why a 2-point deduction? I mean, it's just sort of, there's no actual scoring except for the total, and it certainly brings with it, having participated in it, the danger, if you will, that it's outcome determinative. We've decided we like this person, so let's make a score to reflect that.
Your Honor, the statute and the rule, as well as DAF's guidance, contemplate consensus scoring, and it doesn't require the level of specificity that Waldo wants in this case. This court has reviewed DAF's consensus scoring in the Pine Tree legal case, and it has found that it's a reasonable process.
Counsel, you argue in the brief that there's 2 methodologies that are used here. One is start at 0 in the score range, and the other is to start at the midpoint. But couldn't the other side argue that it's still somewhat arbitrary to say, I'm going to assign a 7-point deduction as opposed to a 3-point deduction? Or a 4-point deduction. I mean, I understand the overall approach, the collaborative decision-making and the overall methodology used may be reasonable and supportable, but I'm focusing now on the actual final decision of that team in a collaborative process. How do they come up with 7 as opposed to 3? What guidance is there? Is there any?
I believe that the testimony was that, like you said, they started at a midpoint and they adjusted up or down. I don't think that there is that level of specificity, but I disagree that that makes the decision arbitrary. It's a high standard, and the DAF's appeal committee considered all 4 of the DHHS evaluators' testimony on how they did the scoring, and they found it to be reasonable based on the information they had before them.
You're resting on the standard that we stated in Pine Tree Legal, which is we vacate the appeal committee's determination only if the nature of the evidence is such that the committee was compelled to find the CAP's contentions highly probable.
Yes, Your Honor, and there was another case as well where this court upheld state agency procurement requirements, which was the Carl Cutler case. And in that case, this court determined that, similarly, that the agency evaluator's process and review of the proposals was reasonable.
And that to the extent the procedure is maybe not perfect or somewhat irregular, you still have to go back to the evidence, whether it compels the committee to believe that the irregularity rendered the selection process fundamentally unfair.
Yes, Your Honor, and I think particularly when you consider the facts in the Pine Tree case, I mean, that was a case where the evaluation team went through 2 separate rounds of scoring, and none of that, my understanding is that none of those details were included in the RFP itself.
But isn't the problem here that there really is no criteria to say that it's a 7-point deduction?
I don't
I
think
mean, why are we using points at all if there's no criteria for it?
Well, there are points assigned in the RFP itself where it says, you know, one section was afforded 50 points, and the section that's at issue in this
Right.
case was afforded 20.
But there's absolutely no guidance as to how within that 50 points, how points are awarded and/or deducted.
That's correct, and I think it goes to the notion that state agencies have flexibility to determine with whom they want to contract for a government
That doesn't
contract.
make it arbitrary?
No, Your Honor. The law has all of these various requirements that take a great deal of time to put together an RFP, to put together a
Can I follow up on that? I mean, I presume that the point deduction must be commensurate with the magnitude of the failure to comply. Is that a fair statement? That the two have got to be tied in, like a very serious error would result in a larger deduction of points. Is that conceptually consistent with what's happening here?
I think so, and I think if you consider, again, the volume of bids that the team reviewed, it was really important, and the RFP put everyone on notice.
It seems that would be really the only criteria is the magnitude of how big the default was, or how large the magnitude of the error.
Yes. And
there's no other thing to hang the number thing on, right?
And in fact, there was another applicant whose score was much lower.
That's correct. And I was going to say, I think given that there were other bidders in this region that scored lower, and also given the fact that, and this is not this case, but there was another bidder that also lost points because of failure to conform with the RFP.
And just to finish my question there, CAP is saying you deducted 7 points. That's way out of whack with what our error was. It really overstates the magnitude of what we did wrong here. Do you care to comment on that argument?
I would just refer, Your Honor, to the DAF's decision, which considered this very point and said and acknowledged that it was I think the decision said it was a somewhat low score, but the appeal committee didn't consider that to be a fundamental error, or that Waldo satisfied its burden of proving by clear and convincing evidence that the award should be invalidated.
Was this a 25-point section in the application?
Yes.
So it's
Your Honor.
almost a third of the points that could have been gained here simply by the fact that they didn't fill in the boxes.
Well, it's not just the fact that they didn't fill in the boxes. The information itself was not there.
Thank you.
So if they had deducted 25 points, would that be a problem? All of it? If they had just said, we're deducting everything because of this particular mistake?
I think perhaps that would be a problem. I mean, that would be a different case.
Do you know what the other bidders' deductions were for, and how that compares with?
I'm sorry, Your
Waldo?
Honor, I don't know the answer to
That would be in the record, though.
Yes.
Presumably. Thank you.
There don't appear to be additional questions. Do you have anything else?
I do want to just clarify that we disagree with Waldo's argument that the RFP doesn't say anywhere where the projects must go. There are the instructions I believe it's at the record at 95 or 98 that tells them that they need 3 projects, and then
95.
yes, and then the form itself has 3 different boxes. And I also, again, want to strenuously disagree with the characterization of Mr. Bondison's testimony. He did not agree that the information was there and it was just in the wrong places. What he agreed to was that if the information had been there and if it had been placed in the correct boxes, then the score would have been higher.
What was the essence of his testimony on that? I mean, what did he identify as the problem with not putting the information in the proper place?
He explained the process that the evaluators went through in reviewing these many thousands of pages of bids and how important it is that these submissions complied with the requirements in terms of formatting and substance. And he said it was just very hard that the evaluators did not understand what Waldo is arguing was supposed to be their other project examples.
Which is why the RFP warns that if you don't follow the particular format, you could get a reduced score.
Correct.
And it's perhaps the most important thing in a bidding process is that everybody has an equal opportunity and you treat them all equally. So if they had deducted nothing for not conforming to the RFP, that might have been a problem.
Yes, I agree, Your Honor. I think that could have been characterized as giving an incumbent bidder preference.
I don't know if you responded to opposing counsel's suggestion that there are inconsistencies within the RFP itself as to what information does or doesn't have to be given. Do you?
Yes, I disagree with that characterization, and I also would like to point out that every other of the 39 other proposals completed the Appendix D properly, and also Waldo had the opportunity, if it was confused about what the RFP said, they could have asked questions, and they did not ask any questions about what the RFP required.
Would it have made a difference from your perspective if instead of NA in the box for Project 2 and Project 3 it had said see above or see projects listed above?
Potentially, Your Honor, but again, we dispute the notion that the information at the top part of that form was consistent with what was required by the RFP. It didn't include details about the different projects or set forth how it related to the experience, and it didn't include any contact information. We understand that some of the referenced information has to do with other divisions within DHHS, but you can't think that the particular evaluators are going to be aware of every other division or particular contract that Waldo may have with DHHS.
Thank you.
If there are no other questions, I respectfully ask that the decision be upheld.
Thank you.
Thank you.
Seven points was a lot. I mean, it was so much that it was the reason Waldo Cap lost the bid. But not only did it lose the bid because of that, it lost the bid in the category of qualification/experience to provide the services when they provided the same services for 12 years.
Counsel, what's your response to the waiver argument that you didn't raise it below?
We addressed that in our reply brief, and the response is simple. If you look at our closing argument before the appeal panel, we specifically cite that statute in a case which cites that statute for the basic concept that we're putting forward in this appeal. In the 100 pages, and in the argument just now, the state is unable to articulate how Waldo Cap is even slightly inferior to motive care in organizational qualifications / experience for Region 5. Yet Waldo Cap scored dramatically lower than motive care in that category and therefore lost the bid. That alone pretty much sums up how baseless and without reason this award was. And Waldo Cap does not believe the legislators intended for the statute to be applied that way in a circumstance like this. Thank you, Your Honors.
Thank you.
Thank you. Thank you, counsel. As is our ordinary practice, we will be taking this matter under advisement, issuing a written decision in due course. I also understand, Attorney Moncure, that this is your first argument in front of this court. I'm not sure why it took so long, but we, as is our custom, we would invite all counsel, or opposing counsel as well, back to take the greetings of the court. seated. The matter before the court is State of Maine versus Nathan Lee, and this is Lincoln 2549. We are being streamed on the web, both by audio and by video. I would ask counsel to introduce yourselves for the record together with the party you represent, starting with appellant.
Kurt Peterson for the appellant, Nathan Lee.
Ken Murdoch for the appellee, the state of Maine.
Thank you. And Attorney Peterson, if you wish to argue, we'd be happy to hear it this morning.
Thank you, Your Honors. Good morning. This case, the issue of paramount importance in this case was the credibility of the witnesses. That is the one thing at trial everyone could agree upon, was that this case came down to the credibility of the witnesses. It wasn't about documentary evidence. There was not videos. There was not an admission. There was no forensic evidence. This case was about the testimony of an alleged victim.
And counsel, since you put the green light on right from the beginning, I mean, both of your arguments obviously have to do with essentially vouching, but the first issue that you've raised with regard to, is it Detective Ferreira, I think?
Yes, Your Honor.
But it was immediately objected to when the question was asked, that it appeared to be about to try to lay foundation to ask a question about credibility. And by the way, I'm not sure it was at the defendant. It may have been for the alleged victim or someone else. But that was objected to. And then that was it. It was sustained. It wasn't asked. The foundation wasn't laid, nor was the ultimate, which would have been the objectionable question, ever asked. How is there an error?
Your Honor, I think the foundation was laid. Looking at that question that was objected to and was not allowed to be answered in context, beginning at the start of Detective Ferreira's testimony, where he talks about his training
But the foundation may have been laid, but the question wasn't asked.
The question was beginning to be asked, and in the context of that statement, this questions that precede that were about the Detective Ferreira's investigation as it related to Mr. Lee and the denials that Mr. Lee made. And so I do think it's important to look back too, because when you look at Detective Ferreira's statements about how he can tell whether someone's lying or not, like a human lie detector, he says that they look for body language, what they're actually saying, them minimizing, embellishing.
And none of that was objected to for some reason.
It wasn't objected to as right off the bat. It was like a question to try and lay a foundation. I think it plainly is error to ask that question, because that's invading on the province of the jury. But then when you look at the follow-up questions, they're all tracking on that same type of human lie detector foundation about embellishing, about minimizing. That's what Detective Ferreira was testifying about on direct examination, was about Mr. Lee.
What should the court have done? I mean, there weren't any objections. You're suggesting that the court sua sponte should have intervened and cut off that entire line of questioning?
Yes, Your Honor. I believe that this was such a plain error that went to what the jury is there to determine, which is the credibility of witnesses, and it is so plainly apparent that we don't allow law enforcement officers to testify that they can determine whether somebody's lying or not based on their training and experience.
But the officer never ultimately did testify, because the court did sustain the objection that was finally raised. There was no testimony about any particular witness in the case and whether the law enforcement officer found that person credible or not.
The officer never got to answer the question that was being posed because trial counsel stepped in. The answer didn't need to be given, though, Your Honor. In this case, the answer was already before the jury. The question that was being posed to Detective Ferreira was whether or not you believed, and again, I would assert that this is Mr. Lee because he's asking questions about Mr. Lee and his interaction, is whether or not you believe Mr. Lee, whether you found him to be credible in his denials that this alleged conduct happened. The question didn't need to be specifically answered. Asking the question and trying to elicit that improper testimony is prosecutorial error, and it seriously affected the result in this case because the jury is the only one that's supposed to be answering that question and not Detective Ferreira.
Well, I guess I could push back, or at least get you to clarify where do you think the question was asked, because in the section that drew the objection was, as you have had an opportunity to view that's when the defense counsel stands up and says, I think and before he even says it, everybody heads up for a sidebar.
Yes, Your Honor.
And then there are no further questions after the sidebar, although I will acknowledge that during the sidebar, there's an indication from the state's attorney that basically he was asking about the training, education, and experience that did he find her to be credible, which is the question he was going to ask. So clearly he wasn't asking, at least based upon this record, it does not appear that the question that the state's attorney wanted to pose was with respect to the defendant.
That's correct, Your Honor.
And again, I take a step back. There was never a question that was concluded before the sidebar.
The question was so plainly, apparently, about the credibility of Mr. Lee because this is what they were asking questions about. I agree that, Your Honor, that the state's attorney indicated the word her, which it makes gives me the impression it's not about Detective Ferreira. But I will even assume, for argument's sake, that it was about her being the alleged victim. It's equally as problematic because the trooper can't, or the detective can't be opining about the credibility of any witness. And I would say it might be more, well, I think it's equally as prejudicial if it's the alleged victim that you're vouching for or if it's the accused that you're saying he's lying. That those are equally prejudicial points of opining on the witness's credibility.
All right. But in that context, that question was never put forward before the jury. That was the discussion in the sidebar.
I think, Your Honor, in the context of the entire testimony, including the initial foundation, the questions that tracked this minimizing type of, this is how we determine if someone's lying, and then the questions before, which were about Mr. Lee, that the question is plainly about, and the jury hearing the question is interpreting this as being, do you believe Mr. Lee or not?
Counsel, can I just be clear of my own thinking on this? You have focused on that question that was cut off and then the subsequent sidebar. Are you suggesting that you're challenging the previous questions as well, and that would be under an obvious error standard, or are you focusing on that last exchange under a plain error?
I do focus on that last question because it directly asks a witness to opine about the credibility of Mr. Lee or the alleged victim. But the court has said that you look at these in context, and I think you have to look at this in context of the entire testimony that Detective Ferreira provided.
Well, then wasn't it incumbent upon defense counsel at that point then to say, Judge, essentially, this isn't just one question. I know you sustained the objection, but they've been skirting around this, and, I'd like an instruction, a curative instruction saying it's improper.
Yes, Your Honor.
But that didn't happen.
That didn't happen. That's why we're here on an obvious error standard of review, Judge, which I think we meet in this case because, again, it's not just about Detective Ferreira's question about the foundation that was laid, but fast forward hours later that afternoon in this trial about credibility, the state's attorney gets up in closing arguments and says that he believes the alleged victim's mother, Lucinda. And Lucinda testified at this trial. The state has 2.5 pages worth of historical facts that are based on Lucinda's testimony. This was an important witness. All of these witnesses were important because that's all this case boiled down to was witnesses' testimony. And so it's not just limited to Detective Ferreira.
Can you explain why you think her testimony was so significant? I assume we agree with you that what the prosecutor said was error. The prosecutor didn't say the alleged victim. I think she was being honest. It was about the mother who wasn't testifying as to the events that actually formed the basis for the charges. So why is it so prejudicial when it was said in regard to the sort of ancillary witness?
So Your Honor, Lucinda's testimony was very important because it corroborated a lot of what the alleged victim was stating about the way in which she grew up in this household, about alcohol abuse, about verbal abuse that happened in the house and with Mr. Lee as her coach, and about the isolation of the alleged victim, which was used to explain the late disclosure that occurred here. Again, so one of the issues that defense counsel pointed out to the jury is how late this disclosure was in order to attack the credibility of the alleged victim. Lucinda's testimony was insulating that credibility by saying things like, she would not have confided anything in me because I would say something to him. She was isolated. That's the reason why she didn't do this late disclosure. So those are some of the reasons why Lucinda's testimony being bolstered by the state's attorney's comments and closing arguments, is prejudicial to Mr. Lee.
Do you wish to comment on the stock instruction that's been given probably for the last 50 years where the judge says to the jury, members of the jury, the statements of closing arguments of counsel are not evidence. Is their impression of how they believe you should interpret the evidence, but if they say anything that goes beyond that, you're to disregard it because you're the judges of the fact. In your experience, do you deem that instruction to be curative of any transgressions that any attorney may make regarding proffering an opinion during closing?
It depends, Judge. But largely, I would say in a case like this, that curative instruction, which is given in a 10-minute statement that the trial judge gives to the jury at the end of a long, tough trial, is not sufficient when, after that instruction's given, the parties in this case then closed. And then the first thing they hear in closing arguments from the state's attorney, or one of the first things that they hear, is that I believe, Lucinda, that the state's attorney believes what she testified about. And so I would say it depends, Your Honor. I think it's important that instruction's given. I don't mean to kind of skirt the question. I think that instruction has to be given, but I do think in my experience it's not always followed. But
I'm guessing I'm asking if you think it should be stronger. It should say something that the attorney's opinions are not evidence, and should any attorney venture into that territory, you should disregard it. But you don't think that's necessary in the general case? If it isn't raised by the evidence? Or isn't raised by the closings?
I'm not sure if it's necessary unless the prosecutor gets up on a closing argument and says what was said here, Your Honor. Then I think it's necessary.
Thank you.
If there's no further questions, I have some time to thank you.
Attorney Murdoch?
Justice in the court, may it please the court.
I see your green lighted, so I'll just ask you the same question.
Perfect.
Do you think that standard instruction at the end of the group instructions should include routinely a reference to attorneys venturing into opinion territory during their closings?
I do.
Okay.
Because any information we can give the jurors to help them make a clear decision based just on the facts that are presented in evidence, and help them understand how the process works and is supposed to work to provide due process to the defendant, which at this point in the trial, all the rights belong to him, or to her, the defendant. I think anything we can do to help that only strengthens the trust in the process.
So you would support us? Well, we don't actually create the standard instructions, but you would support the stock instructions as including a reference to opinion.
I would, and I'll just follow up a little bit on that. I think you've seen a few of these cases. I think that particularly in the rebuttal portions of the during these trials of the prosecutor's closing, they can react to certain things that are said. I mean, our closings are kind of prepared, but the rebuttals are reactive, and sometimes you can misstate or toe the line or walk up to that line trying to rehabilitate or...
Well, let me ask you about that line.
Yes, ma'am.
In closing, you made a statement.
I did.
Was that error?
And that's a great question.
It should be an easy question to answer.
It was, it could be considered error, and I will point out that the court...
I'm going to say it plainly is error.
Plainly error.
To say, I think someone was honest. How is that not error? We can talk about whether it amounts to obvious error and requires vacatur. Counsel, I'm a little disappointed that you have tried to suggest that that is not error. I understand why things get said in the heat. I get that. That's part of the reason we use the phrase prosecutorial error rather than misconduct, to recognize that these things happen. But in the cold light of day after the fact, when you read that statement, what is your justification for not admitting that that was error?
I can admit that according to opinions from this court that that would be,
And the
that
rules
that's
of
error.
professional conduct.
And the rules of professional conduct. But, so I don't want to put a but in there. What I'll say is this. I believe in Dolph, this court said that generally, if there's any witness vouching, it will be prosecutorial misconduct. So in that sense, I believe that we could agree that it's prosecutorial misconduct.
Well, I'm happy to use the word error, as I said, as opposed to misconduct.
Well, that's what I was viewing it as. I think this court has also said that it doesn't view these kind of in isolation. They view them in context of
I said I understand that you may not concede, and I certainly understand why you would not necessarily concede that it is indeed the kind of error that affects substantial rights requiring vacatur. I understand that part. But to suggest that it's not error, to literally use the words, I think someone is honest, is a little mind-boggling, counsel.
Well, if I could go back, I would not have used that language for sure. I can agree that it was error to use that. So then we can move on from there, and I can kind of explain the context.
Well, let me ask you about the other piece, though.
Yes.
You appeared, certainly, to be trying to lay a foundation to the officer to have him comment on the credibility of someone. How is that proper?
I was basing that on his training, education, and experience.
I'm not saying that you couldn't lay the foundation, but how is it ever proper to ask one witness to comment on the credibility of another witness?
It probably isn't. It's not proper. I can concede that.
Thank you. So we can go from there as to whether either of those plain errors require vacatur.
Yes, and I'll start with where I tried to lay a foundation that, based on his training and experience, he at least had some training, and I believe that was proper. That's how trials work. I think I may have will agree that I overstepped for the sake of argument, and then I will say that it was properly objected to, never went any further. Jury never heard anything after that. I think that's how trials are supposed to work. These are long, complicated processes, a virtual cocktail of the personalities and things going on, and so every once in a while there can be misstatements or missteps, and it was properly objected to by counsel, handled appropriately by the court, and that line of questioning was stopped right there. The other thing that I would just point out is that I think I've reviewed this and looked at some of the cases. Again, because this is not an uncommon issue for appeal. And I thought that the case that most closely was on point in this matter was Weaver, State v. Weaver, where there was a single instance where the prosecutor vouched for the credibility of the witness. And then further went on to say that in the context of his entire statement, and by the way, the court found no error in that case or misconduct on the prosecutor's part. He went on then to point out where evidence that was presented at trial could back the credibility of the witness. And I think if we look at this totality of my statement here, it starts with I thought honest, that speaking about the witness who was testifying, who again, I think it was pointed out, she didn't testify to anything substantive as far as the actual conduct that was on trial here, but she did provide background testimony, so it matters. All testimony matters. I went on to say that we need to look look at this. A lot of this will turn on credibility. There are certain things we can look for when we're looking to see if people are testifying credibly. And then I go into stating that the woman who testified was brutally honest about her behavior. And somebody who's that open and admits to that many mistakes and that kind of character conduct that she had during this period wouldn't come up here and not be credible. It goes to her credibility.
But you realize you invoked one of those hot button words there when you said honest. You know, for the prosecutor to say lie or honest probably should be a red flag going up. And to the point where I think you're headed here, which is harmless error, we're faced with a conundrum, which is we've seen a lot of cases where prosecutorial error has been alleged, and we said, yeah, it is error. but the other evidence is so overwhelming that we're going to call it harmless error. And that may create, I don't know if it does or not, but might create in a prosecutor's mind, I've got a really strong case here, so I can really take this over the line. If I get dinged on it later on, we still have the conviction. I don't know if that's the thought process, but that's something we certainly would not want to encourage. And the other thing that concerns us is when we identify prosecutorial error, but harmless error, it may create a de facto pre-approval of whatever happened in that particular case there. It becomes like the outer margin, which it really isn't. So the frustration for us is when, and it's always going to be challenged by defense, because that's one of the things that they look at very carefully. And we don't want to create a body of law where the outliers become the standard of what happens, if you follow what I'm saying.
No, I know exactly what you're saying.
Because there are ways to do it that don't involve those forbidden words. I guess I'm just mentioning that here because you've acknowledged the youth, that word in there in the sentence that you are going to say is harmless error. I think if the word could be spread to the prosecutors, hopefully not necessarily through decisions of the court, but within the prosecutor's own organizations, that invariably the defense counsel during closing is going to be attacking the credibility of the prosecution's witness, and you say, well, it resonates in your heart saying, these people are good, honest people, and they're attacking them. So restraint is the order of the day, and I guess I'm looking for you to explain to us how we can get the word out that the outliers that are deemed to be honest, harmless error are not the go-to limitations.
Yeah, and well, for me, this process has brought that home. You will never see me up here again.
It was intended to.
Yes. Well, I'm getting that from the court, and I appreciate it. But I'm my harshest critic. I can do better. I actually remediated this by talking to other prosecutors and see how they did it and how they handled it, in particularly around the state. And we just had the prosecutors conference, so I had an opportunity to meet with other people from the state and talk about this. I would think that the way to get the word out is to, at the prosecutors conference, have a little CLE on closings and to do talk about this and talk about what you just mentioned, that we don't want to be stepping up to the line or having these outlier cases have to control going forward. And I think that that can be handled pretty easily because they're always looking for topics to discuss for these, and it would be great if one of you would come and talk to us about it, because I do, as I mentioned before, I was able to review a fair amount of cases for this exact same conduct, and I will say it's not. I think as far as prosecutorial misconduct and as far as error goes, I don't think they're bad faith. No,
As I indicated, that's why we intentionally changed our language to prosecutorial error rather than misconduct.
Yeah.
To recognize misconduct sounds like there's always bad faith involved or intent involved. And to recognize that there isn't always bad faith or intent involved, it is nonetheless error.
It is error.
So the immediate question in this particular case, now that you have been penitent, is this obvious error? And I think what you're saying and what you said in your brief, after you said it was an error, you then said if it was an isolated statement, and thereafter it was a recitation of the actual evidence. She wasn't speaking to the direct incident as an eyewitness or the defendant. And the closings always say, don't pay any attention to what the closings say, that's not evidence. And all of that together, you're saying, means it's not affecting substantial rights, which is required for obvious error, correct?
That is correct. Thank you. That is what I'm saying. I will also point out that,
You should be an appellate artist.
I'll also point out that in my closing, I also say, just to drive this point home, that it's just when you're trying to gauge credibility, and I'm speaking to the jury, I just ask you to think about what people go through here and how the process process works and the stress it puts on them, dealing with some inconsistencies. Another point in my closing, I say, I'll leave it to you, the jury, to decide on the credibility of the witness. And then, again, I say just another thing to think about when you're thinking about credibility of the witnesses. So I didn't want to, I don't think that my intent was to usurp the jury's responsibilities, fact finders, and to determine credibility and the weight of the evidence. I think that was inartfully stated. Won't hear it come out of my mouth again. And I will also say that, as a side note, that I still have a little PTSD for conceding points, because I don't know if you remember the last time I was here, I conceded a point, and I barely continued to practice law after that. So I was hesitant I thought I had enough, based on Weaver, dicta or at least context, to get myself out of the error. But I do concede that it was error, yes. Just to put it in context, why I may not have been as...
Was that a York County argument?
Yes.
Okay, I think I know what you're
So maybe now you remember. I think I confused Justice Connor during that argument.
I'm not surprised.
Yes, so, and I apologize for that. But so, yes, but, and again, I think that going forward, we can all do better. I strive to do better and always learn from the trials and review them. And we actually have debriefings in our office to see what we could have done better. And I do think the CLE is a good idea, and we'd be happy to have one of you come speak.
Thank you, counsel.
Thank you.
Attorney Peterson,
You're
I'm
all-
not sure you can actually rebut some of what he said.
I'll try, Judge. I appreciate Deputy DA's Murdoch's candor, but it's not enough. This case isn't the case where someone's caught in the act or someone makes an admission or where there's forensic evidence. This case is about the credibility of the witnesses. That's it. It boils down to that. The state admits that it boils down to that in closing argument. So again, I appreciate the candor, but it's not enough in this case. The only thing that should occur in this case is a vacature of the conviction and remanding for a new trial, because Mr. Lee did not have a fair trial, because the state invaded the province of the jury to allow them to determine credibility. Instead of doing that on their own, they were able to think back to Detective Ferreira's remarks. They were able to think back to DDA Murdoch's remarks and closing arguments. For that reason, I asked the court to vacate the conviction for a new trial.
Thank you.
Thank you.
And thank you, counsel, for the arguments. As is our ordinary practice, we will be taking the matter under advisement and issuing a written decision in due course. And with that, we will be in recess for the lunch break.
All rise.